Hello and welcome to the Help with Debt channel. My name is Steve Thatcher. I'm the owner and principal of Help with Debt. Today I'm going to talk about wrongful trading. This is especially prevalent if you're if you're a company director. Being a director of a limited company in today's economic climate can be tricky. Trading conditions now are as hard as they've ever been, and restrictions on the availability of credit combined with lengthening delays in payment are putting cash positions under strain. As a result, many companies will and are running into financial difficulties. Now, directors must take early decisions as to whether or not the business can continue in such circumstances or should cease to trade. Failure to do so may result in the directors having to contribute personally to a company's losses. Now, under insolvency legislation, a director may be liable for wrongful trading if a company trades whilst insolvent. Specifically, if you as a director knew or should have known that a company could not avoid becoming insolvent but still continues to trade, then he or she must cease to trade immediately and take steps to liquidate the company. A failure to do so, which results in further losses being incurred which could have been avoided, could result in that director being guilty of wrongful trading and be made liable to personally pay back those additional losses to creditors. Therefore, a company which is in financial difficulty must ensure that there is a reasonable prospect that the company will avoid insolvent liquidation before being a party to any decision to trade on. The warning signs are there if you know where to look. Now, in many years in insolvency, I often bemoan the fact that directors of companies experienced in financial difficulty had taken too long to read the warning signs and approach me for advice. The following steps must be taken. Directors should always meet regularly to discuss the business and any potential problems. Number 2, the most accurate and up-to-date financial information must always be available. 3, note-taking of all these meetings is important as they can be referred to and relied upon at a later date. Number 4, any decisions you make should be regularly reviewed. And number 5, if at any stage there is a concern about the continued viability of the company, then you have to seek advice. This may not mean that the company needs to cease to trade, but it could help you if you're called upon in later negotiations with a liquidator to explain why you didn't take an action at a particular time. Now, directors can escape wrongful trading liability if they can prove they took adequate advice and precautions to keep the losses to creditors to a minimum after it became apparent that the company was insolvent. In order to do that, you need to call me on 0808 160 5577 or email me sthatcher@helpwithdebt.co.uk. Thank you for listening.